Hi, everybody. Good afternoon. I am Tiffany Puckett, and I'm an associate professor of law in the College of Law here at Northern Illinois University. Prior to this school academic year, I was an associate professor in the College of Education. And so I didn't leave Northern, I just switched over to the different colleges. I have a J.D. and a Ph.D. both from University of Illinois at Urbana-Champaign. There was some time in between the two. I practiced law full-time first and then went back to get a Ph.D. I do have a Ph.D. in education leadership. And prior to entering academia, I was a school attorney for about 10 years for DC public schools and Baltimore City public schools. So a lot of my research now comes from my experiences as a school attorney, my experiences as a teen parent, my experiences as a first-gen person. I say first-gen, I'm first-gen high school grad, first-gen college grad, and there's a lot of first-gen attorney language, too, so I'm first-gen attorney, and I didn't know that until we got into the law school. They're like, are you first-gen? I'm like, first gen, high school, or first gen what? Like first gen high school, first gen college, yes, but there's in the law schools they talk about first gen lawyers because a lot, yeah. So anyway, and the majority of my work as a school attorney was in special education litigation, and I would say 90% of the time. And so I've continued my work in special education. I am on the board of directors of the Education Law Association. I'm also on the executive committee for the American Association of Law Schools Education Law Committee. I'm on the standing committee for the American Bar Association status of paralegal. So I got a lot of stuff going on right now. But what I want to talk to you today about is the future of IDEA. The future of it, because I really, and law scholars, me included around the country, we really just don't know what education law stands right now. I did my dissertation published in 2016 related to IDEA and special ed litigation. There have been calls for a long time for reauthorization, meaning an amendment to IDEA. IDEA was established in 1975 under a different name, but it has been reauthorized 3 times since then, 1990, 1997, and then most recently in 2004. I entered the practice of law in 2000 and became a school attorney at the end of 2003, so I came in right at the beginning of the changes, right at the amendments, which I think were significant, and they had some different really good impacts, improved accountability, teacher qualifications, changes for dispute resolution and discipline. These are not all the changes, but a few that were really instrumental, allowing for longer IEPs, requiring secondary goals and transition services for students at the age of 16, and also getting rid of the short-term objectives and benchmarks. And I don't know if you've been involved in the development of IEPs prior to 2004, but staff spent a lot of time prior to getting rid of benchmarks and things. Also, the requirement that we have highly qualified special education teachers and the discipline changes. So a lot of my research, and I just recently published, Education Law Association does a lot of publications for school leaders, and so we have a publication called Principals Legal Handbook, and I wrote the chapter on disciplining students with disabilities. And so most of my research recently has been related to students with disabilities. I believe that IDEA currently, the way it's written, there's some changes need to be made to make sure we have more equitable discipline practices for students with disabilities. The changes that were put into place in 2004 related to disabilities included stay put provisions, allowing educational placements for up to 45 days in the case if a student brought a weapon, serious bodily harm, or drugs, the requirement of FBAs and functional behavioral assessments, and also giving hearing officers more leeway in allowing for placement changes when there's a safety issue. Another thing was allowing and encouraging the use of mediation, requiring the use of resolution meetings prior to due process hearings, and then I think that this was a great step, but you will see that I think that it's still needs to be some changes. There's been no amendments, even though there's been calls for amendment. There's been proposed legislation. I think it got sidetracked with COVID, and now Now we got another sidetrack. I just really don't know where we are in regards to the future of education law as it pertains to students with disabilities, and I'm really concerned about it for many different reasons. Why are reauthorizations and amendments to laws important? Laws need to be updated to address new challenges. I mean, we're 20 years outside of the last amendments, and educational needs for students have changed. Society has changed. When we look at literature and other research related to this area, scholars argue that the current law does not account for modern changes in mental health. It also does not account for the discipline disparities that are happening every day related to students with disabilities. It also does not account for remote learning, something is a new thing for us. Advocates have called for increased funding, better accountability, and updated provisions. I indicated that two of the big areas that I study are discipline and due process. For the law school, I teach education law, contracts, and another thing that I was hired for was alternative dispute resolution because of the, just dealing with conflict and conflict resolution, etc. But when I did my dissertation, I wanted to focus on that dispute resolution part. Is IDEA providing parents with a tool to really make complaints against the school district? And so when I did my research, obviously at that point in time I was at Baltimore City Public Schools, so I'm like, I'm gonna use the state that I'm in, and so I looked at the whole state of Maryland. I believe it was for 4 years, and when I looked at it, I found that if something made it to a full due process hearing, if a parent did not have an attorney, they did not win, not one case. Now, I didn't think about this, and I didn't start thinking about this until I pulled myself out of the school attorney hat lens. Like, I knew there were equity issues in the education system, but when I went back and I left the full-time practice of law in 2012, after being a school attorney for almost 10 years, it really jumped me into like, whoa, I got down to U of I in law school. I did a master's in education policy, so I went back to my department and decided I was going to do the Ph.D. in education policy and leadership. So it pushed me back into like really looking at these issues. That was like, I didn't think about this. I'm telling you, because I would sit in my hearings, my due process hearings against parents. I'm like, oh, okay, it's the parent does have an attorney. This is a good one. It's like, let's roll. But okay, so let's think about that. No attorney, no win. Like literally no attorney, no win. So I was looking at, did some regression analysis and some other things, statistical analysis to see, hey, is there a relationship between capital and winning? So social capital, educational capital, economic capital. It was, higher the median household income increases the students' chances because they were able to have an attorney. So when parents won, they had an attorney. Private school placements funded by the parents. So if students are already in the private school placement, it increases their chances of a successful outcome, increasing the number of witnesses, so the ability to present. But guess who did that? The attorneys presented that. It wasn't the parents presenting that. The attorneys were increasing those witnesses, and so that increased their outcome. Now, this is 2016. Prior to me doing a study, other scholars have done studies on this area and other areas that they think should be changed under current 2004 IDEA. And so, but some of my recommendations were, in order to minimize special education litigation, we need to review current programs as well as meeting legal requirements. So I'm saying we, the school districts, require a school law course for our educators. A lot of things are due to lack of legal literacy. Our teachers, I had a group of doctoral students in the College of Ed where they looked at legal literacy and they looked at the requirements under colleges of ed across the country and teacher education programs, and there really isn't any. Few states have a little class here and there where students who are going to be teachers had to do some sort of legal training, but most of them don't. And so just being a former school attorney, like if the teachers understand the law, we can prevent a lot of legal things. And then even worse, like teachers really don't understand general education law, but they definitely don't understand special ed law. And a lot of general ed teachers think special ed is not their problem. It's only the problems of the special ed teacher, which is not true. I'm a big advocate of you cannot separate law and education. They go together, but I don't know how much they go together anymore. And also IEP facilitation. Illinois does offer IEP facilitation. A lot of states do not. One of the main other things I'm thinking that if there is a reauthorization, mandatory mediation. Now, the current law allows for mediation and encourages it, but when you look at states and you look at the ones who when parents actually use mediation, it's likely that their complaints are resolved faster, etc. Mediation can potentially have a positive impact. You see my eye is still on there because these are my slides from my dissertation. When we look at 2004 IDEA, there are a lot of gaps, funding shortfalls, delays, and that need to be addressed. Things that need to be addressed through an amendment, delays in evaluations, IEP implementation, discipline disparities, mental health gaps, transition services for adulthood, racial and economic disparities, assistive technology issues, and limited support for ELL students. A lot of different barriers going on. Some people want the federal government to continue to control this area. Some folks want the state to control. It's a lot going on. And if you've been watching the news, we really don't know how all of this is going to play out. IDEA is currently funded. When it was initially established, it was supposed to fund up to 40%, but it has not funded that. There's been a request for increase in funding. Some of the things that an amendment needs to change is the delays in evaluation. Schools have backlogs in evaluations. Parents are often need to file complaints to even get students evaluated. Discipline disparities. Students with disabilities are disproportionately suspended and expelled. They're not only disproportionately expended and expelled, they're also disproportionately arrested. So when you look at arrest data, manifestation determination reviews often not applied correctly, and schools lack behavioral supports. When we look at what's going on with transition service, there's been calls for stronger vocational training programs. Some call for transition plans to start before 16. So right now, 2004 IDEA says you can start at 16, but there's a push to start it earlier. A lot of schools, like a lot of middle schools right now, are starting transition planning discussions earlier with the general education students, so some are calling for additional changes. Overrepresentation of Black and Latino students having an emotional disability, under-identification for conditions like autism, inequities in access of high-quality special education, situations where people are over-identifying disabilities for students who are English language learners when they don't have a disability. It's just that they're not being provided the language services necessary. So there's a lot of things going on, changes that need to be made in assistive technology related to our English language learners. Schools lack resources to properly evaluate English language learner students with disabilities. They're either under or misidentified. There's a need for bilingual special education services. And so there's a whole bunch of things going on in regards to changes that need to be happening. And so there's been calls for changes, but currently right now, if you guys are watching the news, over half of the U.S. Department of Ed essentially has been let go, and then there's also reports that there's going to be a dismantling completely of the U.S. Department of Ed. And for those of us who work in this space, being a former attorney, I had a lot of interaction with the U.S. Department of Ed, Office of Civil Rights, also the Office of Special Education Programs and the Office of Special Education Rehabilitative Services regarding to making sure that our school district is in compliance and making sure that students with disabilities are receiving the needs that they have with the schools. And so I'm not sure, what education law is going to need to be complied with at this point or not, and I'm not sure how this is going to look as of maybe next week. Thank you. Historically, there's usually been bipartisan support for IDEA. If you look at the history of IDEA, I'm just not sure how this is going to look now, especially since when you have now, like if we're taking the federal government out and we're turning everything over to the state, which is my understanding. Like these are just reports. We have not received anything. The president has not signed any new executive orders or anything at this point, so it's a lot of speculation. A lot of the speculation coming from news outlets, etc. So I have not seen anything. I can't say that special education policy is going to be there's going to be a lot of bipartisan support this time around because it's a huge change. So right now, if you look at special education law under state laws, it's highly modeling what IDEA says. Like literally because some states have just copied in their laws what's required. So if we end up getting rid of the requirements under IDEA, under the federal statute, and we're turning into a state argued issue, because this has always been something that has been, since 1975, been guided from the federal level. I don't know, I can't speak to what the partisanship, how that's going to look under state arguments related to it, because states have always been able to provide, required to provide this, at minimum, what the federal government requires. You can give students additional rights, but you can't take away rights. And so because they haven't had an opportunity to have, since 75, none of the guidance of IDEA, or, we don't forget, we have ADA, we also have Section 504. If those are going to be just not even enforced, and because when you get rid of the U.S. Department of Education, essentially, so if we're not enforcing it, then I don't know how that's going to fall in arguments in state legislation, especially if we're saying, hey, states deal with students with disabilities. But I do know that historically there's been a lot of support for services for students with disabilities, but I can't predict things anymore. I don't even try to, so I'm not sure. When you look at graduate school education, so our psychologists, speech, these are individuals, our related service providers have had some sort of special education law training. It's the teachers, when you look across the country, who most states are not requiring education law to be there. So school psychologists are, their legal literacy on education law is high. A lot of school psychologists are coming through programs where they're required to have some sort of training in education law. Because what their work surrounds around, when they're doing those evaluations for students with disabilities, they need to understand some of the language. And so I believe that you cannot separate education law and schools, because so much around what happens in the schools and what is required by your position as a teacher, position as a related service provider, is guided by education law and policy. And so if you don't understand that, or you just listen to the person next to you, then we have a lot of non-compliance in our schools, which increases the potential for litigation for parents. So if you got a whole group of folks who don't understand special ed law, a lot of general teachers don't really think that they're supposed to understand special education. It's like I've heard many different times from folks that's not my problem, that's a special education teacher's problem. It's even hard sometimes to get a general ed teacher to really pay attention to a student's IEP. I've heard general ed teachers tell me that, no, this is a special education problem. I don't have to implement this. Well, that's not true. Nothing has been issued yet, but I'm concerned because there are so many things under the previous authorized law that I believe need to be changed to make sure that many different student populations that have disabilities need to be able to have better services, and we just don't know if we don't know if we're going to be able to change that.